Hello everyone, welcome you back to our channel, Igbo Mindset Adeba, and today we are going in for constitutional law, and our topic of emphasis is the doctrine of separation of powers. So, by the end of this session, you should be able to know how to attempt a question about separation of powers. You should be able to identify the philosopher who formulated the doctrine of separation of powers. You should be able to define the doctrine of separation of powers. You should be able to discuss all the three arms of government. You should also be able to discuss the doctrine of checks and balances, to also apply the current day situations in the topic separation of powers. And to dive into it, I urge you colleagues, if a question comes about the principle or the doctrine of separation of powers, I call upon you to first of all discuss pure separation by Montesquieu and apply it in the 1995 Constitution, how powers are separated. Secondly, we discuss the three arms of government. What article creates it? Under which chapter is it found? Its independence. So you continue to look at the doctrine of checks and balances as a must. You should include those three. So to begin it, the doctrine of separation of powers is a constitutional principle that divides government into three distinct branches. That is the legislature, the executive, and the judiciary. Why is it the doctrine of separation of powers? Why is it crucial? To protect concentration of power in any single organ. As simple as that. So, before going to the philosopher who formulated the doctrine, let us look at a scholar, John Locke, who stated that where there is a solid separation of powers, then we are bound to have a very good constitution. So, from there, for him, he said that where we have a solid separation of powers, we are bound to have a very good constitution. Now, the doctrine of separation of powers was formulated by a French philosopher called Montesquieu in his book, The Spirit of Laws, a book of 1748. So, there are many statutes which have come in to define the doctrine of separation of powers. And on the international scale, Article 16 of the Declaration of Rights of Man, 1789, provides that any society in which the safeguarding of human rights is not assured and the separation of powers is not observed, that society has no constitution at all. So, if we go back to Montesquieu's principles, Montesquieu, separation of powers to him basically meant three things. He said that each organ of government should be operated by different people. Each organ of government should be independent from the other. No organ of government should interfere in the affairs of the other. So, we are going to see the case of Major General David Tinyefunza versus Attorney General, Constitutional Appeal number 1 of 1977, where the doctrine of separation of powers was exemplified. Justice Kanye Hamba noted that the principle of non-interference by the judiciary in the legislature and executive matters shall prevail. So, in the same case, he mentioned the political questioning doctrine that there are some matters of the executive which are political in nature that the legislature, that the judiciary shall not review. So, let us now see how is power separated in the 1995 Constitution. In Uganda, in the daily life, as a serious student, you should discuss how each organ of government is led by different people, as Montesquieu said. Now, if you go to Article 99, Clause 1 of the 1995 Constitution, it vests executive authority in the president. And If you go to Article 133, Clause 1A of the 1995 Constitution, it provides that the Chief Justice shall be the head of the judiciary and he shall have all binding force on the administration of the judiciary. And if you continue to Article 82, which says that the Speaker shall be the head of Parliament. And we have been seeing each organ of state being operated by different people. Now, we are going to continue where Montesquieu said that each organ of state be independent of the other. So, here I urge you colleagues to discuss the independence of each organ of government, to discuss the article which created that particular organ of government, and to begin with the independence of the judiciary. We shall first see Article 126 that creates the judiciary, which says that judicial power belongs to the people and shall be exercised in the name of the people with values, norms, and aspirations of the people. And Article 128 of the 1995 Constitution provides for judicial independence. The judiciary is independent from the other organs of government. In the 1995 Constitution, separation of powers is observed in that way. And if you go to that article, you shall find there the principle of independence, non-interference, judicial immunity, self-accounting, and the security of tenure of judges. And if you continue to search for the independence of the judiciary, and you go to Article 92 of the 1995 Constitution, which says that Parliament shall not pass any law to alter the decision of any court, the non-retrospective nature of the law. You get. Now, let us continue to the independence of another organ of government, parliamentary independence. We said that we should first talk about the article which creates that organ. And Article 77 creates parliament. There shall be parliament of Uganda. And its purpose is to make laws. So if you go to Article 79 of the 1995 Constitution, it states that nobody other than Parliament shall have power to make laws. If you continue to Article 94, Clause 1 of the 1995 Constitution, it states that Parliament may make rules to regulate its own procedures. That is independence of Parliament. It is not intervened by other organs, as per Montesquieu said. And if you continue to a case of Miriam Matembe versus Attorney General, where a court stated that the judiciary shall not intervene in the process of making laws by Parliament. So let us continue to independence of the executive. How is the executive independent from other organs of government? So to trace it, you can look at various articles, but I'm going to give you Article 98, Clause 4 of the 1995 Constitution, which says that while holding office, the president shall not be liable to any suit in any court, whether civil or criminal. Now, let us go to the last principle of Montesquieu, that no organ of state shall take over power of the other. The principle of non-interference. So, we are going to look at some cases where non-interference was emphasized. And to begin with is the case of Chandler versus Attorney General. And in that case, court held that the judiciary will not review the process of exercise of discretionary powers by other organs unless there is abuse of the discretionary powers. You get, unless there is abuse. You can also use this case for checks and balances. So you go to the case of Miriam Matembe versus Attorney General. We have already discussed that one, where a court stated that the judiciary shall not intervene in the process of making laws by Parliament. And if you continue to the case of Major General David Tinyefunza versus Attorney General, Constitutional Appeal number 1 of 1997, where Justice Kanye Amba stated that the judiciary shall not interfere in the affairs of the legislature and the executive unless there is abuse of human rights. Now, we have discussed the three organs of government, connoting them to pure separation. How is separation purely applied in the 1995 Constitution? We have seen the articles, we have seen the cases which emphasize the same, and now let us go to the doctrine of checks and balances. And this is like an exception to the doctrine of separation of powers, the pure separation by Montesquieu. So, though the 1995 Constitution has observed an extent of pure separation, it has, however, adopted the doctrine of checks and balances. And the 1995 Constitution has adopted the doctrine of checks and balances to serve as an exception, to create an equilibrium, to create interdependence, to create an antagonistic relationship. Get me very well, colleagues. The doctrine of checks and balances is, is putting up a principle that no organ should use its powers of independence to become unruly. If it goes overboard, another organ comes and says, no, here you have gone beyond your limits. Like we have said in the case of Major General David Kinyefunza versus Attorney General, where Justice Kanye Amba said that the judiciary shall intervene in the executive and legislature where there is abuse of human rights. So we are going to continue and see in the 1995 Constitution, we shall see the present day affairs, how the doctrine of checks and balances is exemplified. And Justice Benjamin Odoki used the three cooking stones to define the doctrine of checks and balances. And for him, he said that when those three cooking stones, when one stone is not present, or when one stone is removed, the two cannot deliver. The doctrine of interdependence. And to go to the 1995 Constitution to trace for checks and balances, we shall start with Article 91, Clause 1 of the 1995 Constitution, which says that the power of Parliament to make laws shall be exercised through bills passed by Parliament and assented to by the President. It means Parliament shall issue a law, a bill, but to become a law, it is the President to confirm checks and balances. What kind of law are you trying to introduce? Is it harmful? Is it useful? The doctrine of checks and balances to create equilibrium, to create interdependence, to create a sense of non-antagonistic relationship. And if you go on to see Article 121 of the 1995 Constitution, which talks about the prerogative of mercy. And this one, when the judiciary sentences people, the president has authority to pardon them. Like I don't recall the year, but it was the year of elections, the previous elections, where the president pardoned some NUP members. So let us now continue to Article 142 of the 1995 Constitution. And Clause 1 says that the president shall appoint judicial officers with approval of Parliament. You see, it is the president to appoint the judicial officials, but Parliament approves to see is that person competent. And if we continue to Article 118 of the 1995 Constitution, which talks about the vote of censure of Parliament to dismiss a minister. Remember, a minister is a member of the executive, but you see, Parliament sits and creates a vote of censure to dismiss the same minister. Checks and balances. If you continue to Article 100 of the 1995 Constitution, notification of the Chief Justice and the Speaker by the President when he is leaving the country. The doctrine of checks and balances. And Article 107 of the 1995 Constitution, which talks about removal of the president. It is Parliament to sit and say that this man is now becoming incompetent. That is the doctrine of checks and balances. If you continue to Article 113, Clause 1 of the 1995 Constitution, where cabinet ministers shall be appointed by the president and approved by Parliament. checks and balances. And if you continue to Article 137 of the 1995 Constitution, which talks about interpretation of the Constitution, it is the judiciary which makes laws, but however, the legislature interprets. And remember, the word of the Chief Justice is a law. If the Chief Justice talks, the doctrine of precedence, you see, now the judiciary is intervening in the power of Parliament to make laws. And if you continue to Article 108, Clause 2 of the 1995 Constitution, where the President shall with approval of Parliament, appoint the Vice President. The President is appointing this Vice President, but however, the Parliament has to approve such. And if you go to Article 119 of the 1995 Constitution, in the clause 1, where the Attorney General is appointed by the President and approved by Parliament. And if you continue to Article 120 of the 1995 Constitution, where the President appoints the DPP with approval of Parliament. If you go to Article 122 of the 1995 Constitution, the President may appoint ambassadors, those ones who are going abroad to discuss matters of national importance on behalf of the country, but still they are approved by Parliament. If you go to Article 124 of the 1995 Constitution, which talks about declaration of state of war, it is declared by the President, but however, approved by Parliament. So, we are going to see some instances. This one is now a student who is extraordinary from others shall include this in their essay. Now, let us see these instances, the present day, where the organs have checked each other. And of recent, you have seen a certain document circulating. It is, the lady is called Judge Aisha Naluze, whom the Uganda Law Society advised to resign as immediately after she was appointed as the IGG. She is a judge, but appointed as the IGG. So, the Uganda Law Society is advising her to resign. We should talk about those instances. And you can see the election petitions of the president. The president is the head of the legislature, but now he goes to the judges to sit and determine his fate. Election petition. If you go to the 1st March 2007 sage of the High Court registry by the Black Mambas, the Black Mambas stormed the High Court registry to prevent the processing of the bail papers. You should also talk about those instances. You can also talk about the instance where the Chief Justice ordered for the trial of Dr. Kizza Besigye in a civilian court. But however, the President maintained it that Dr. Besigye should be, if he wanted a free and speedy trial, he should accept to be tried in the military court. I don't want to go into politics much. I thank you for watching Legal Mindset at the Bar. Subscribe and we move together. Share this video to your friends if you think it is useful. Thank you very much.